First of all, I'd like to welcome you all to the meeting today. Thank you for coming and thank you for attending virtually. This is the new world as we know it. I'll introduce the session in just a second, but before I do, I'd like to give a shameless plug here for CSNW Benefits, if that's okay. If you don't know us, I'm Dan O'Doherty. I'm the president and CEO of CSNW Benefits. We're an employee benefit agency here in Portland, Oregon, and this cover the entire state of Oregon. Yeah, I guess what I would say is at CSNW, we help our employers, our clients build innovative, customizable, cost-effective healthcare benefit packages. I think our strength is that we partner with our clients to bring state-of-the-art compliance tools, HR resources, much like we're going over today, benefit-related technology, and we're trying to continually improve and adapt our clients' employee benefit plans to meet sort of the changing needs of their workforce. For example, a COVID pandemic is one of those things that we're facing right now. In addition, I think we have a pretty sharp focus on customer service, and our goal is to be an extension of your team, your go-to resource when you or your employees have challenges from an HR or benefit standpoint. So that's really our goal, and we think how we do it makes us the premier firm, employee benefit agency here in Oregon. So if you're not already a client, feel free to reach out to us, and we'd love to talk to you. So we've invited Cascade employers and Jenna specifically to present on the topic of HR fundamentals today, because we think Cascade is the resource that every employer in the state of Oregon should be aware of and should utilize. Cascade is a nonprofit that supports HR needs of their members. We're members of the organization ourselves, and I can't speak highly enough of them. They're phenomenal. Just in addition, our firm partners with Cascade as the managing general agent for their association health plan, and that's a plan that helps small and mid-sized employers access large employer benefits. And so if you haven't received a quote on that particular health plan, please feel free to reach out. Those rates can be incredibly competitive. Our speaker today is Jenna Reed. Jenna is the Vice President and HR Services General Counsel for Cascade Employers Association. As an employment law attorney and HR professional, Jenna helps members understand and navigate complex regulatory environments, advises on current and practical HR solutions, and lends her expert support so employers can confidently take on their biggest HR challenges and opportunities. Jenna inherently seeks to understand your specific circumstances, obstacles, goals, helping you sort through the clutter and determine your best path. Her collaborative and responsive and solution-oriented approach creates workplaces where employees and organizations thrive, not just survive. A nationally recognized speaker on employment topics, Jenna is also a member of the Oregon State Bar Association, or State Bar, I should say. Jenna, thanks for being here today. Thanks for talking on HR fundamentals, and we really appreciate your insight. So thank you, and take it away.
All right. Thanks, Dan. Appreciate that great introduction. And yeah, at Cascade, we feel very fortunate to partner with CSNW on our benefits support. So our members get such great service from CSNW. And as Dan mentioned, some really great rates as well. So we're really excited that we have such a strong benefits team supporting our members and aligns with what we are all about as an association as well. So this morning we're going to be talking, we have a very short amount of time to get through all of the HR fundamentals. So it's going to be very high level information here. If you find yourself wanting more information, you can certainly visit our website. We have tons of different training programs. Really on each one of the topics that we're going to be talking about today, we have separate classes that are dedicated to just those topics. And so that's at cascadeemployers.com. And so as we go through this, I'll try and monitor chat with the understanding I'll try and answer questions as they come up. But because we do have a lot to cover, I may need to save some of the questions till the very end. So if I don't get to your question, I'll try and get back to it at the end of the session. But I will be monitoring chat as we go along. So definitely feel free to put your questions there as well. So we're going to go ahead and get started. We're going to start off with sort of basic risks and statistics, and then kind of work our way through the employment relationship from sort of pre-hire issues all the way through to the end of the employment relationship. So we want to look at who is likely to file a claim. And when I say claim, we're talking about they might contact the Bureau of Labor and Industries. They might contact the Equal Employment Opportunity Commission, OSHA. They may file a private lawsuit. So there's lots of different ways that employees can make claims. So we want to look at what are some of your odds, and how do we make sure that you aren't one of those statistics. And just being here and getting a little bit of information today is certainly increasing your odds that you are not one of those statistics. So I'll ask you guys for a little bit of feedback here if you want to enter using the chat. So what percentage, employers win what percentage of lawsuits? Why don't you go ahead and enter your answer in that chat. Let's see how we're doing here this morning. So just go ahead and enter what you think is that percentage there using chat. So go ahead and enter those answers. 26, 33, 26. All right, 26. So we're definitely on the lower end. Oh, we got someone who's feeling fairly optimistic with that 53. Most of you are on that lower end there. So what we're looking at here is this 33%. So not 26, 33% is still not a very good statistic there. And smaller employers are particularly at risk. Have a 12% chance of being sued. And so that's not a great statistic. And the reason why smaller employers especially are at risk is because a lot of times HR is a piece of someone else's job. And so HR might not be your area of expertise. So that's why it's really important to make sure that you do have these fundamentals in place to manage sort of that risk of a claim coming your way. So what are the most common claims here? Wage and hour claims. Anytime you're talking about people's money, how much they're making, there's a lot at stake there. In Oregon in particular, and Washington as well, is very strict on wage and hour rules. Discrimination, harassment, retaliation are going to follow that with the top claims there. And then family leave claims. Oregon and Washington have a lot of laws around family leave, and they just got more complex this year with all of the COVID leaves that are in addition to what already existed. So this is where we're going to spend kind of a little bit of our time, is looking at what are these most common claims to help you manage. And this is really to just build your knowledge, and at the end we'll talk about what are the tools that you need in place and kind of build your checklist along the way. So again, another scary statistic here, $125,000 is the average cost to defend a lawsuit. And that doesn't necessarily even include all of your settlement fees if you end up settling there. Those can certainly increase there. So we want to make sure you're not one of these groups here by at least trying to get some base in place to make sure that you're managing risk. So this is kind of a peek behind the scenes with what our consulting team is. We are taking calls and emails constantly throughout the day to respond to issues that employers are facing. And it could be a discrimination claim, it could be a performance issue, it could just be hey, someone's not taking their breaks, or how much overtime. So you name it, we're helping answer those questions for employers. But this is kind of one of the, the checklists that we're listening for as we're engaging with companies to kind of help us figure out, could this be a higher risk situation? So things that we're listening for that you want to be kind of running through your brain as you're dealing with an employment situation is this going to be a surprise termination? So employees that feel surprised by the action that's taken against them, they're more likely to make a claim. And another statistic that I didn't mention, but or sort of trend, I guess, not necessarily statistic, but what we do see is that when unemployment is high, we see employment claims also significantly increase, because it's more difficult for people to find jobs, and so they have more also time on their hands to reflect about their employment experience and kind of grind on why did they lose their job, those sorts of things. So when unemployment is high, employer risk increases as well. So anytime it's a surprise situation, we know that risk is going to increase. And this kind of, when it's a surprise, what we're talking about is they haven't been put on notice. There's no documentation or really bad documentation. And so while you may have had a conversation with that person about their performance, and you might call me and say like, hey, I've talked to them about this 10 times. This shouldn't be a surprise. And I say, well, I agree, but where's your proof that you talked to them? Where's the proof that you were actually putting them on notice? And that's that differentiator there, is we have to have good documentation. That's really that second bullet there. Not provided an opportunity to improve. So we didn't put them on notice. We didn't give them good documentation so that they knew like, hey, if I don't meet this expectation, I could lose my job. Former employee that's told it's just not a good fit. That's just a suspicious answer. People then will sort of make their own conclusions about, what do you mean it's just not a good fit? Is that because of my gender or my race or my age? They'll go and they'll talk to their friends and family, who are obviously going to be supportive of them. So we don't want to rely on saying something like, it's just not a good fit. What we want to make sure is that, what does that mean? It's not a good fit because this is a really collaborative environment, and this employee fails to engage in meetings. They don't collaborate with their colleagues. Whatever that happens to be, we want to be able to articulate those reasons there. Supervisors are going to be your greatest risk point, because they don't have all of the HR knowledge necessarily that you may have, even if HR is just a smaller part of your job. So investing in some supervisory training for anyone that is responsible for supervising employees is really, really important, so that they at least know what to do and how to spot issues. So you think of like a basics of supervision class that teach them how to be effective supervisors, but also helps them be able to identify high risk situations or potential legal issues, and that they know the process to follow. So now now that we've kind of talked about scary statistics, we're going to move into who actually even is an employee, because sometimes there's a lot of confusion. I find particularly with small employers are more at risk for classifying someone as a contractor rather than an employee. Oregon has very, very strict rules about how an employee is defined compared to an independent contractor. So in general, what we're looking at is who has control and direction over the work. Is it the employee, or is it this individual? Is it the permanency of the relationship? So is this something that is for like 6 months, a defined period of time, or is this indefinite? Then we also look at independent business factors, such as who bears the risk of loss. What investment is the individual making? What skills are required? Are they doing this for other individuals? Whose equipment are they using? So all of those factors can help us determine whether someone is an employee or contractor. I find that employers are particularly at risk right now with the economy and with unemployment. What I have seen employers do is maybe they will have laid someone off, and but they maybe want to call them back as a contractor to do some work. And if they don't meet the sort of requirements that we're going to be reviewing, there's a huge risk, because what happens, and what I've actually had several members have happened, is they called these employees back. They said, hey, we just need you for this contract work. The employee is using the company's equipment. The company is directing the work. They're not doing this for other people. And sometimes they're doing the exact same work that they were doing as an employee. And so maybe that project goes away after a few months, it ends, and then that employee files for unemployment, right? And the employer says, no, they were an independent contractor. And the employment department's going to take a look at that and go, all right, well, you were directing the work. They were using your equipment, your schedule. They're not doing this for any other people. They're doing the same work that they did when they worked for you as an employee. Guess what? They're your employee. You owe back wages, benefits, all of those sorts of things. It can be really, really expensive to misclassify. So if you do have contractors, now is a great time to evaluate those relationships. So from the employee perspective, the individual providing service for an employer perform for remuneration or under contract of hire, written, oral, express, or implied. Work is directed and controlled by the employer. So again, we look at the employer you're using their equipment, under their schedule, their specific processes. So the person really doesn't have their own independent discretion and control. They can't hire other people to do the work, versus a contractor free from direction and control over the means and manner of providing services. So a lot of times you look at contractors, they also might be like vendors that you have. So a lot of times it might be someone who's providing IT services. Bookkeeping is a very common contractor relationship, because a lot of times bookkeepers, right, they're going to collect your information, put it through their own processes. They're doing it for other organizations. So you want to be careful of that. These are in general. Again, as you go through your own analysis, you're going to want to dig in a little bit. So this is kind of the highlights. Contractors are paid by the job, and they're negotiating the terms. So there's a negotiation process. The contractor is responsible for the results and determines their own details. So again, they're determining the process, those types of things. They operate as an independent business, offering the same services to others, making investments, that they have insurance, that they're bearing the risk of loss, that they're using their own equipment. They can hire other people, right? And the services that are being done are not integral to business operations, sort of why the business exists. So this is your general framework. So if you are using independent contractors, make sure you are reviewing this. I've seen a lot of employers making mistakes in this area right now, because having a contractor is very attractive, because you're not paying all those payroll taxes and benefits and all of those sorts of things, workers' comp, all of that. But if you screw up, it's very, very expensive. So high risk area right now. So hopefully we've got an idea of who our employees and our contractors are. So next thing we want to do is look at at-will employment. What is at-will employment? This is probably one of the most, I would say, misinterpreted areas of law, because it says one thing and kind of means another. So an employee can be terminated anytime for any reason, with or without notice. You probably all have this type of statement in your handbook somewhere, but that's not really what it means. There's this big but there that says, well, let's straighten this out. You can terminate an employee at any time for any reason, with or without notice, as long as it's not for an unlawful reason. So at will is really for employees. They can leave you at any time for any reason, but you have to make sure that when you are terminating someone, it's not for an unlawful reasons. And there's lots of unlawful reasons. So for example, the big one that we're looking at is you can't terminate someone based on a protected class, whether that's intentional or unintentional. So you don't even have to intentionally discriminate. You can unintentionally discriminate against someone. Both are going to be unlawful here. So things that we're looking at in terms of, we can't take these things into consideration in any employment decision, not just termination, but it could be hiring or how we determine wages, promotions, those sorts of things. So these protected classes, some of them you're going to be very familiar with, are covered under both state and federal laws, and some of them are specific to Oregon. So for example, domestic violence, harassment, sexual assault, or stalking, specific to Oregon there. Gender identity is specific to, it's actually now covered because of the Supreme Court. It's not phrased in this specific way, but it is covered now under both state and federal because of a Supreme Court decision this year. So as you're making any employment decision, even if it's not a termination situation, you always want to be looking at, hey, could it look like one of these protected classes has been a factor in this decision, right? And that could be for a benefit or a consequence. It can go both ways. So again, my consulting team, when they're talking with you all and trying to understand your situation, we're also listening for, gosh, does it look like you could be treating this person differently because they just took family leave, or because of their age or their race? So this is something that we're always monitoring for, that you want to be looking at as well. So in addition to protected classes, there's also protected activities. So there are certain things that employees have a right to engage in that we can't use it against them. For example, they have a right to file an employment claim with BOLI or EEOC or OSHA. It's their right. We can't tell them that they can't do it. And we can't treat them differently if they do. They also have a right to testify in an employment proceeding or for the state legislature. They also have a right to take protected leaves if they're eligible and you're a covered employer. So we can't use those protected leaves against them to deny employment. They have a right to oppose unsafe working conditions. This year, OSHA has received a record number of complaints. I think over 12,000 complaints, and normally they get, about 1,000 to 2,000 a year. So already in 2020, they're way over the number of complaints. Employees have a right to do that. We can't use these things against them. Employees can talk about their wages and other terms and conditions of employment. So we can't have a policy that says, hey, you have to keep your compensation confidential. That would violate Oregon law, as well as under the National Labor Relations Act. So again, keep protected classes, protected activities in mind as you're going through. The other thing that we're always looking for is the timing of an issue. So for example, if someone makes a harassment complaint and then all of a sudden they're terminated, that could look like retaliation, right? So we're always looking at those timing issues. So here's an example of a high risk situation from a timing standpoint. So in this situation, we have an employee has poor performance. We don't have any documentation proving their poor performance. Maybe we've talked to them about it, but we don't have anything documented. And they're actually given an annual review and a raise. So their review says, hey, they're doing fine. So we don't have any documentation. We don't have any review that says they're not meeting expectations. But then this employee takes family leave. All right. So they come back from family leave, and that family leave is protected. We can't use it against them. They come back, and all of a sudden we're talking to them about their poor performance. And they're thinking, why are you talking to me about my poor performance right after I got back from family leave? This was such an issue. Why didn't you talk to me about it before? Why did you give me an average annual review that didn't show that I wasn't meeting expectations? High risk, because that looks like retaliation. Versus less risky, and it's less risky, you're not going to have no risk. You're dealing with humans, and humans are unpredictable. So this is really just about lessening your risk. So in this scenario, we have the same thing. Employees is engaging in poor performance. We don't have a write-up or performance improvement plan, but we do give them a poor annual review, and we don't give them a raise. So now the employee continues to be a poor performer. This time we write them up, put them on a plan. They don't get a good review, another poor one. They continue to not get a raise. Now they make a harassment complaint. And we're going to make the assumption that the company has done a thorough investigation and taken reasonable action and followed that process there. The employee continues to be a poor performer, and so we terminate. Our risk is very well managed because this person was put on notice, provided an opportunity to improve. They knew what the expectations were, and they knew what the consequences would be if they continued down that path. So a much less risky situation, but again, not zero risk. It's just well managed in that. So always think about timing issues. I always have employers, when I'm talking to them about sticky issues, I say, send me your timeline. I want you to write out things because I want to see how this is looking from a timeline standpoint. Another really quick filter that you can use when dealing with situations is asking these questions. Can you answer these questions out loud, right? And on the flip side, these are the questions that your employee is asking as well, right? So if they were denied a promotion, they're asking, why was I denied, right? Why was I denied now, right? Where's the documentation? So on the flip side, you need to be able to answer that. Why is this happening? Why is it happening to this employee? Sometimes there's that ... and why not someone else, right? That's sort of the employee thinking, Joe has really terrible attendance too, so why isn't it being addressed with him? Well, Joe may have terrible attendance, and maybe it is being addressed with them, but that gets to the consistency side of things. Why is it happening now? Why is it happening right after I made a harassment complaint, right after I called OSHA? That's the timing piece. And can I prove it? Do you have the documentation to say, hey, this is exactly why this is happening. You know, those first three don't have a lot of weight if you don't have the proof. If you don't have the documentation, it's still going to be a high risk situation because you're asking a judge or a jury to take you at your word, right, without actual evidence, and that's can create some problems there. So hopefully you have a good understanding of at-will employment and what those limits on at-will are. So now we want to look at, when we're bringing people into the organization, what are the things that we want to make sure, sort of the basic things that we're paying attention to. So one of the things that you can do to help yourself is make sure that you're using a new hire checklist. Really important to make sure that you've got the basics covered and you're being consistent. So things like, do you have a job description in place? Do you have their I-9 form, right? All of those things. Do they have passwords? Do they have access to your networks? Just create a new hire checklist. You want to make sure your job postings have EEO language in it, which is your statement that you are not engaging in discrimination. You also want to make sure that you require an application. Make sure that application is up to date and doesn't include any prohibited information. We'll review that in just a moment. Make sure that you have accurate and up-to-date job descriptions. Your job descriptions are just about as important as your employee handbook because it says this is what's required to perform the job. So it's a hiring tool that you can use to screen out people, screen in, screen out based on what the job description says. But then it's also a performance management tool to say, are they meeting these expectations of the job description? And, you know, job descriptions probably this year have changed a lot with everything going on. So if you haven't updated your job descriptions recently, now's a pretty good time to do that. And then making sure that you're in compliance with pre-employment inquiries and agreements as well. I'm not sure why my slide isn't for. All right. Go back one more there. All right. Sorry. Hopefully you don't have motion sickness. So pre-employment inquiries. So there are some restrictions in Oregon. You cannot make any criminal inquiries about an individual until after the first interview. So if your application asks for, you know, hey, have you ever been convicted of a crime or a felony or anything like that, it needs to be off of your application. That's prohibited. If you are in Portland City proper, you cannot make any criminal inquiries until after a conditional offer of employment. And then you also have to make sure if you are doing a criminal background check, you have to comply with the Fair Credit Reporting Act notices. Oregon also significantly limits credit checks. So the reason is because an individual's credit isn't a good indicator of their ability to be a great employee. So no credit checks allowed unless it's substantially job related. It's your accountant, it's your CFO, that type of position. If you're going to require that credit check, you have to provide written notice explaining why that check is substantially related to the job. And again, you have to comply with the Fair Credit Reporting Act notices. Medical exams and inquiries need to be done post-offer. So if you have medical exams, there are definitely limits on that. Sometimes organizations will have physicals. Make sure that they are narrow in scope and specific to the job that individual is being asked to perform, and not just a general health inquiry. Drug testing should also be done post-offer. Typically, drug testing is done. Employment is contingent on passing the drug screens. I'll also just make a note. I see a lot of employers that have made this mistake, that they've actually allowed people to begin working before they get these results back, before they get drug tests. I just was talking to a company. They made an offer to someone. They allowed them to start working, and they got their drug screen back, and they failed their drug screen. Now you're in a really difficult situation. So make sure if you have those pre-employment pieces in place, you actually are waiting that employment is truly contingent on those pieces. So new hires, a couple of things to pay attention to. All new hires, all employees are required to have an I-9 form. It has to be completed within 3 days of hire. Two different pieces there. The employee has to complete their portion on the first day. The employers have until 3 days to complete the rest of the form. I-9s need to be stored in a separate folder, separate from their personnel files, not in their personnel files. And then you also need to complete a new hire reporting form within 20 days. This is a state form, and it's basically used for child support tracking, so that if somebody has child support, the state knows where they're working and could potentially garnish their wages. Make sure if you're using offer letters are definitely recommended to make sure that there's no confusion about what is being offered in terms of their compensation, first day of work, all of those sorts of things. So make sure that a really good practice is to get signed offers so that there's no confusion about what that person is entitled to. Employment agreements, if you have other agreements like a non-compete or a non-solicitation, non-disclosure agreement, make sure that you get those signed as well. And back, handbook acknowledgement, so make sure that every employee receives the handbook, and acknowledgement at the end that says, yes, I received it, and that goes into their personnel file. Same thing with the job description. So I-9 form, I just talked about that, so we're not going to talk about that anymore, but you do have the slides if you want to dig into that. But there is a new I-9 form that was published this year, so make sure that you do have the newest I-9 form. I don't have the date off of the top of my head, but it was earlier this spring that new I-9 form was available. So just make sure that you check and have the most current date there. So now kind of moving in, we've got someone hired, things that we want to look at. This is sort of wage and hour issues. How are people being compensated? So you want to take a look at your exempt and non-exempt employees. So your non-exempt employees are entitled to minimum wage, overtime. We've got to make sure that they're tracking all of the hours that they're working, making sure that they're taking their breaks and their meal periods. And your non-exempt employees can be paid hourly or salaried. So I find this is another sort of high risk area is, and I'd say more common with small employers, is that making the assumption that because someone is paid a salary that they're automatically exempt. That is not true, because there's a dual test. One, in order to be exempt, they have to be paid a salary at a certain threshold. And the second part of that test is their job duties have to meet certain legal requirements as well. So you can have salaried, non-exempt employees. So don't make the assumption that just because they're salaried, they're automatically going to be exempt. That's why your job descriptions are so important, that they're accurate and up to date there. So with your non-exempt employees, make sure that you are tracking all hours worked. Some employers we have seen struggle with this a little bit in the remote environment. There's so much great technology available, so employees can use web-based programs, mobile apps to track that, to allow employees to track all of their hours. So again, for exempt employees, what I just mentioned was they do need to be paid a salary, and that salary threshold increased last January 1st to $684 a week. It was $455 prior to that. And then you see we have this duties test. So there are different categories: executive, administrative, professional, outside sales, computer professional. We don't have time to get into all of those definitions there, but if you are trying to determine if your employees are exempt or non-exempt, we definitely have resources on our website. You can also visit the Department of Labor or the Bureau of Labor and Industries to look at what those specific duty requirements are. But typically what you're looking at is your higher level positions that require an advanced degree, advanced training. So it's typically not your supervisors, depending upon how you define your supervisors, but you're looking at people that have a higher level of independent discretion and control, that they're supervising at least 2 people, those types of things, or high level, like controllers. They may not supervise anyone, but they might be responsible for a core business function. So think of like in a smaller organization, you might have an IT manager who isn't responsible for maybe managing any other individuals, but their job is to manage this core business function there. So that job description is really key in making this determination. And again, just because You say it's exempt, doesn't mean that it is. Just because they're paid a salary doesn't make them exempt as well. All right. So for your non-exempt employees, we do have to pay them for all of the time that they are working, and it's suffered or permitted. And that's just kind of a fancy way of saying if they do the work, even if you don't know about it, we've got to compensate them for it. So things that we're looking at, donning and doffing, kind of again a weird legal term there. But what that's meaning is if someone's having to put on specialized equipment or like think of like certain PPE, like a clean suit, you're going into Intel, you have to put on a clean suit and it takes you 5 or 10 minutes. You have to pay them for that time because it's basically a condition of their employment. You know, if they have to wear steel-toed shoe boots, they can put those on at home. You don't have to pay for that. But it's really looking at, hey, there's more than just, right, putting on a protective coat type of thing. We have to pay employees for your again, these are just specific to your non-exempt employees. If their meal periods are interrupted, we've got to pay them for that. Employees are entitled to a 30-minute interruption-free meal period. There are specific rules around travel time about what gets compensated and what doesn't. So again, we don't have time to get into those specific rules. We definitely cover those in our wage and hour classes, but you want to pay attention to those because there may be times when you are required to compensate someone when maybe you think you normally wouldn't. There's also specific rules around on-call time, and mostly those rules are going to depend upon how much the individual can use their time and how restricted is their time. And the big thing here is any unauthorized work off the clock. So they go on, you know, they're normally working 8 to 5 and they log back in at 7 to clean up their email. They didn't ask for permission to do that, but they did it. You have to pay them for that. So make sure that even if you have unauthorized off the clock work, if they do it, you pay them. Then you probably need to have a conversation with them about why they're doing that. So non-exempt employees, again, overtime rules. So these are just general rules. There are some industry exceptions here, but in general, anything over 40 hours a week gets paid at time and a half. Remember, your exempt employees not eligible for overtime. It's that guaranteed salary. There are specific rules for manufacturing that limit the hours. So anything over 10 hours in a day is going to be eligible for daily overtime. So if you're in a manufacturing environment, you're basically having to do 2 calculations. You're doing daily and weekly, whichever is more is what you end up paying and compensating that employee. Manufacturing also has a maximum hours of work that employees can perform, no more than 13 hours within a 24-hour period there. So 13 on, 11 off is what they need. Also, if they're working a shift of 8 or more hours, they have to have a rest period of 10 hours in between. So again, if they have that 13, that 11 off would still be within that there. And then there's weekly maximums as well. So weekly maximum of 55, but the employee can consent up to 60. And then there are certain times of year. This is typically with like food processing organizations or companies that, you know, like during harvest where they can't just limit those hours without having to hire a bunch of new people. And so this says for a temporary period of time, you can pop up to 80 hours, 84 with consent there for a small period of time. So rest and meal periods, again, this is for your non-exempt employees. 6 hours, if they work a shift of 6 more hours, 30-minute unpaid meal period. That's in the middle, as close to the middle of their shift as possible. Uninterrupted. So that means if you stop them in the middle of their break to ask them to respond to some emails, to make some copies, to make a phone call, you've now interrupted that 30 minutes. You've got to pay them for it as well. And then for breaks, for 10 minutes for every 4 hours or major portion thereof. Breaks are mandatory. They can't be skipped or combined. Little bit different rules up in Washington there. So if your employee says, hey, can I not take my breaks today because I want to leave early to go pick up my kid from soccer? No, They can't skip their breaks. Now you might say go ahead and leave early, but you still need to take your breaks. So they can't be skipped. It's not up to the employee. They don't have the right to waive here in Oregon. And then there's also effective January 1st, lactation breaks. So if you have an employee that needs to express milk or nurse, then they can take lactation breaks as needed as well. All right. So now we're going to take a look at leaves. There's so many different reasons. You can take a look at here, all of these reasons why employees can be away from work. And the list that you see here is, these are protected reasons, meaning we can't use it against them. We're not going to get through all of these different leaves. We're going to hit on a couple that are really important. So the Oregon Family Leave Act applies to employers with 25 or more employees, and you can see the eligibility. So if you're less than 25, you can take a little snooze, but pay attention just for your own education, or maybe you're kind of hovering around that number here. So 25 or more employees, and then the employee has to be eligible. So they're eligible if they work for you for 180 days of employment, averaging 25 hours a week. And then you can see all of these reasons. So people can take parental leave for the birth and bonding of a child, adoption or placement of a foster child. If they have a serious health condition, or their family member has a serious health condition that's going to result in them needing to be away from work. So serious health conditions, think of like chronic health conditions, inpatient care, something that requires a regimen of continuing care. It's generally not like the flu or having a cold, something like that. Some COVID can qualify as a serious health condition. Certainly if someone was admitted to the hospital because of COVID-19, then that would generally qualify as a serious health condition. Or if they have ongoing complications, then that may qualify as a serious health condition. But you may have people that are COVID-19 positive, asymptomatic, so not considered a serious health condition because it's not something that they're being significantly impacted by. We also have sick child leave for Oregon. Sick child is where you have a child that can't go to school or daycare because they have a cold or flu, but it's not a serious health condition. That's probably the most common reasons why employees are away from work. So note here is, anytime you're going to terminate or discipline an employee for attendance, make sure that you have tracked all the reasons for their absences to make sure that they're not protected there. So if you had an employee, you're a covered employer, they're a covered employee, and they called in 10 times because their child was sick and couldn't go to school, you cannot consider those absences. You have to take them out of the equation. So really important that you pay attention to these reasons. And the amount of leave is 12 weeks, but there are some exceptions that extend that. So then we have the federal sort of equivalent here, which is FMLA, Family Medical Leave Act. It applies to 50 or more employees. So if you're 50 or more, you're also covered under OFLA as well. You can see different eligibility requirements. OFLA was 180 days. This is 1 year of employment, and this is 1,250 hours of work preceding the leave. And the reasons for leave, sometimes they're the same under both OFLA and FMLA, and sometimes they're different. So for example, we just looked at sick leave was a reason under the Oregon Family Leave Act. You see that it's not a reason for leave under FMLA. So again, we have a whole series dedicated to family leave laws. This is just to get it on your radar to start thinking about some basic pieces here. Oregon also has protected sick leave. So all employers in Oregon must provide up to 40 hours of protected sick leave per year. Employers with less than 10 or 6, if you're in Portland, have to provide that up to 40, but it doesn't have to be paid. So if you're a really small employer, you still have to provide and protect the time off, but it doesn't have to be paid. If you're more than 10 or 6, then it is paid sick leave per year. So there's a minimum that employees have to accrue. It's a rate of 1 hour of sick time for every 30 hours worked, which ends up being 0.033. They have to track based on actual hours worked. So it's really important that you take a look at your policies to make sure that you don't have policies that just say you get, 4 hours a month, because that might not meet the minimums, especially if that person has worked overtime. So you either need to set up your system to accrue at least the minimum, right? At least at that 0.033. And so an accrual system that meets that minimum, or you can front load. So you can front load time, but if you front load, you have to front load that full 40 hours. I still see so many sick leave policies that do not comply with Oregon law, and this law has been in effect for 4 years. So if you have a sick leave policy or PTO policy, make sure you've had that reviewed, because I do see a lot of mistakes with sick leave. And then this one, I know it's really tiny on your screen, but this is for leave under the Family First Coronavirus Response Act, which is expanding family medical leave. And so what you just noticed was that with a family medical leave, it said 50 or more employers. Well, under this, the EFML and the EPSL, it applies to any employer with 500 or fewer. So a different eligibility requirement there. And again, this is specific to COVID-19 related reasons, and it is paid leave as well. Now, the amount that you're paying is eligible for tax credits. So you can get a payroll tax credit for those for those wages that you are paying for those employees that are using this type of leave. Now, this leave is scheduled to expire and sunset December 31st. We have no indication at this point whether that's going to be extended or not. I have not heard anything about it being extended, because there's a kind of a whole lot of other things going on. But that's just something to put on your radar. This flow chart, I believe, is available on our COVID-19 Resource Center. Even if you're not a member of Cascade, if you go to our website, at the top, you're going to see a COVID-19 Resource Center. We have made tons and tons of information available to any employer, even non-members of Cascade. There's tons of FAQs and resources on there to help you get into compliance. If you are a member of Cascade, you have even more resources. You're going to have sample policies, additional forms, all of those sorts of pieces there. So this is the newest one, but we'll see what happens with this one. We're always sending alerts out to employers as well. So a couple of other things as we wrap up our time here today. Documentation, as I mentioned at the beginning, that, right? Why this employee, why now, can you prove it? Documentation is so important, but I will caution you, I've seen a lot of bad documentation as well. So when do we want to document? Contemporaneously means just be timely. Don't wait to document something that happened 6 months ago, right? It's going to create some credibility, some trust issues if you're dragging up things that were from an incredibly long time ago. So formally, and when I say formally, I mean it's going into their personnel file. So formally, when you're attaching some sort of consequences or benefits, so their job is on the line, or they're at risk of disciplinary action or reduction in pay, anything like that, formally, when consequences, so that means they need to sign it. It goes into their personnel file. Informal, which is typically kind of, you do informal first and then it leads to formal. So informally for recollection at a later date, and there's not necessarily any threat to the employee's job or aspects of their job. Typically this is when you're engaging in coaching of the employee, like, hey, they're not meeting this expectation, but you want to take some time to make sure that they understand what's expected, that they've got the tools and resources, if they need some additional training. So you're just providing support. But you want to create a record of when you're meeting with them, when you're having those conversations. And a trick that not a trick, I guess just a tip that I really, really like to create documentation from those informal conversations is I like to create like an email follow-up. Hey, just wanted to connect. We talked about these things today. Just wanted to kind of confirm this is, where we need to be with these are the expectations. Just take a quick look to make sure we're on the same page. Let me know if you have any questions. Because now you have some really good documentation, and it also helps manage that risk of, those conversations when you think you agree to one thing and someone else heard something else, and you find out, months later that, oh gosh, I didn't hear what you were communicating. And so we were on completely different pages there. So good documentation's timely, it's accurate, it's specific, it's factual, it's not personal, right? And accurate means it's not inflated and it's not minimized as well. Clear and concise, complete, signed, and dated. I will just make a quick note on documentation. This applies even to emails that you might be sending from a personal email account, text messages, social media posts. Anytime you're communicating in any way, shape, or form about work or someone at work, that can potentially get pulled into a discovery situation in a lawsuit. I'll give you an example of bad documentation. I had one of our members who had an employee who was approved for intermittent family leave. They had a back issue. And this particular employee had a habit of calling in and saying they needed to take family leave when they knew that there was going to be a day where there was going to be a lot of physical work. Now, their medical certification didn't give any suggestion that the employee shouldn't be working on their days or that it would just happen to flare up just on those physical days, if there was any risk in them actually performing. It was really that this condition could flare up unpredictably. Well, the pattern that was, this doesn't seem to be an unpredictable pattern. The predictable pattern was every time we're going to do hard work, you call in and say it's going to be a family leave day for you. So this manager is seeing this pattern emerge and he's getting really frustrated. So one day this happens, employee calls in, and so the manager gets on his text and he's texting a few of the other managers and says, hey, so-and-so called in today and they're not coming in. Of course not, so predictable. They're just lazy, they don't want to do their work, and I think he's trying to set us up for an ADA claim. Well, what happened was he also sent that text to the employee because the employee had the same first name as one of the other managers. So he called me, he said, uh-oh. I said, yeah, uh-oh. Bad documentation. So just be really, really careful with your documentation. So performance problems and misconduct. This is just to, sometimes people are like, I don't know how to structure the conversations or the documentation. And so this is just a really quick slide. Print out this slide, share it with your supervisors as these are the steps that you want to follow. We talked about the importance of timing and how critical that is. But here's sort of the path of the conversation, and your documentation really kind of tracks along with this. So the conversation is identifying and defining the problem, right? And specifically, don't make it personal, right? You're supposed to be producing 5 reports per day, and you're producing 2 reports per day. And then we want to explain the impact. Here's where it's going to change. Have them explain the impact. So when the expectation is 5 and you're producing 2, what type of impact do you think that might be having on the team, on our customers? Get them talking. Even though you have an idea about what the impact is, do not lead with that. Get them talking. And the reason why we want to get them talking is so that it is resonating and we have a stronger chance of the solution sticking. So the next one, analyze the reason. Help me understand why this is happening. Again, you may have your own ideas, and I say supervisors make this mistake all the time. Here's the problem, and here's what you need to do to fix it. And we miss all this in-between stuff, and we solve the wrong problem. Because maybe the reason why this person is not meeting that expectation is because they were never told that the expectation is 5. Maybe they don't have the tools and resources that they need to do it. Maybe they didn't get the proper training. Maybe they just don't have the skills or interest. We need to ask them. And then you can add in and ask questions. Well, what about this? Do you think this might be impacting? And then we want to define the expected performance standard, right? The expected performance standard is 5 reports per day or week or whatever it happens to be. And explore ideas for a solution. What ideas do you have that might help improve so that you can continue to be successful in this position and meet expectations? And then that last step is documenting this, and you're just really documenting these first 5 bullets there. So really, really simple, easy process to follow, really important in terms of managing risk and put employees on notice. So last thing that we want to look at here as we wrap up our time is before you terminate anyone, make sure that you are taking time to review written policies, to make sure that you've got your documentation, to make sure that you can answer those 4 questions. Why? Why this employee? Why now? And do you have the proof there? Because that will get it to a lot of those things that we talked about. Is this potentially discriminatory? Have they engaged in protected activity? Have your expectations been clear and reasonable? This is the mirror. How have you contributed to this situation? So important as well. Any limits on at will? Do they have an employment contract or something like that? Make sure you're reviewing their entire work record, documentation, and then make sure you're acting consistently. Using a termination checklist can also help you from a technical standpoint to make sure, like, hey, you've got password returns, company property return, those types of pieces, and then making sure that you're complying with the final pay rules, which you can see here. So the last thing I want to provide you with are just some tools. This is sort of your checklist as we leave here today, and then we'll take a look at your questions here. Making sure you have a handbook that is updated. My goodness, if you haven't updated your handbook in the last 2 years, it's probably significantly out of date. Tons of changes in 2019 and even more in 2020. So if you don't have a handbook, you need to get that updated. Same thing with your job descriptions, as we've seen a lot of job duties shift this year. Make sure you have an application that you've reviewed it so that it doesn't include any of that prohibited stuff that we talked about. Offer letter, if you're not using one, consider using one. We talked about a new hire checklist, I-9 forms, leave forms. If you're an employer that has more than 50 or more employees, the family leave forms were updated this year, so you need to make sure you have those new forms available. Termination checklist, make sure you have templates for your performance improvement plans, for potential misconduct coaching as well. And again, make sure that you have supervisor training. It's your best defense, really, is making sure that your supervisors have some education. So resources for you, certainly I would encourage you to visit our website. We've got a ton of information, tons of trainings available here. I did mention our coronavirus response or resources page. You can follow us on our social media. The Bureau of Labor and Industries, EEOC, DOL, and some COVID ones that you can actually subscribe for updates. Hopefully a lot of you are doing this with Oregon Health Authority, and then through the governor's office as well. You can subscribe to those to get regular updates to figure out what is going on. So with that, looking at how do you manage without that HR manager, we talked about training your supervisors to take more responsibility, some basics of supervision. I do a class that's HR and employment law risk management just for this purpose. Is there someone that you can develop internally to help that? What can you outsource? Payroll and time and attendance, very common one, really reasonable right now, some really great resources. We work with Paycom, who's really great with employers of all sizes, but great with small employers as well. Can you outsource recruiting and hiring to save some time in that area? And some of you are like, who's hiring right now? We actually have tons of employers who are hiring. It just really depends on the industry. Some of our companies, they cannot find people fast enough. What about policy development? Can you outsource that handbook update? Benefits administration. So CSNW is a great resource for our members on the benefits side of that. They provide tremendous support to our members. Training. Can you have external HR consultants provide on-demand support? So we have staff that acts as a company's HR department and fulfills that role. There's resource groups and memberships as well. So with that, I'm going to take a look at the questions. I know we're a little bit over time here. So let's see here. What if the employee won't sign the formal documentation? Is it still valid? Yeah, so you just, Julie, you just want to make sure that if an employee refuses to sign the documentation, right, employee refused to sign, this is why it's also a really good idea in, when it's this formal conversation, it's a good idea to have, another manager involved in that conversation so that you do have a witness to that. So I see that same question there from Julie. Materials will be emailed. Question about you work for a school and teachers sign a yearly contract. If we do not offer a contract for the next year, it's the same as terminating them. That depends on how what's communicated at the end of the contract there. But yes, it may be considered terminating them. Some of them have provisions that will actually last for 12 months rather than 9 months. So it would really depend upon the language in your contract. So that is the end of my time. I stole a couple of minutes. Happy to answer any other questions, or Dan or Jennifer, if you guys want to jump in and close us out.
Sure. There was just one more question about when you update the handbook, do you need to have employees acknowledge that?
Yes.
Yeah, in writing.
Yeah, so anytime you update your handbook, you want to get a new acknowledgement from your employees. Yep, good question. And do you have opinions of using a PEO for a small business? I do have opinions on that. There's some great parts about a PEO, and then there's some not so great parts about that. We could definitely kind of talk offline about that. And I'll be honest, it really depends on the PEO that you go with. Some are really fantastic, and some I have found to be pretty poor. But it is a good way to manage some expenses. But I would say, the biggest factor is going to be what PEO are you moving ahead with there. But for a small company, it can be a good way to manage some risk and expense.
Perfect. Well, Jenna, thank you so much for your time. I appreciate it. We stuffed a lot of information into a very short period of time. I mean, this is, we could probably spend a whole day on this information. So I would encourage everybody, take a look at Cascade Employers as an association. It's a membership organization for a small, an insanely reasonable annual fee. You get access to a ton of HR resources. And so please take a look at them. You can go to their website, cascadeemployers.org, I believe is what it is. But it'll be in the materials. So thanks again, Jenna. We'll get the materials to everyone after this meeting. If you have questions, we're happy to connect you or do the best we can to answer those. But I hope you felt this was time well spent this morning. So thank you so much.